To welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law Number 2. You have been asked to come to court this morning for what we call arraignment. And what the arraignment is, it's an opportunity for the court to tell you what you've been charged with, what your options are, and what your rights are concerning your case. Now, the case that you have in this court is a criminal case. Criminal cases are divided into felonies or misdemeanors. The case that you have in this court is a misdemeanor case. Your felony cases are normally referred to as your most serious type of offenses. And your misdemeanor cases are normally referred to as your petty offense. It does not mean that they're not serious. It just means that they're not as serious as a felony offense. And when I use the term serious, what I'm talking about the possible punishment that a person can receive if they're convicted of the offense and the facts of the case. Now, felony cases are divided into 5 categories. We'll start at the top and work our way on down to the bottom. You have the capital murder, first-degree felony, second-degree felony, third-degree felony, and state jail felony. If a person is convicted of a state jail felony, the range of punishment is minimum 6 months to a maximum of 2 years in state jail, and a fine that does not exceed $10,000. If a person is convicted of a third-degree felony, the range of punishment is minimum 2 years to a maximum of 10 years in the state penitentiary, and a fine that does not exceed $10,000. If a person is convicted of a second-degree felony, the range of punishment is minimum 2 years to maximum of 20 years in the state penitentiary, and a fine that does not exceed $10,000. If a person is convicted of a first-degree felony, the range of punishment is minimum 5 years to a maximum of 99 years to life in the state penitentiary, and a fine that does not exceed $10,000. Now, if a person is convicted of the highest felony, which is a capital murder, the range of punishment is life in the state penitentiary without the possibility of parole or death by lethal injection. Now, as I mentioned earlier, your case is a misdemeanor case, so you don't have to worry about the felony punishment. Now, misdemeanors are divided into 3 categories. We'll start at the top and work our way on down to the bottom. You have the Class A misdemeanor, the Class B misdemeanor, and the Class C misdemeanor. If a person is convicted of a Class C misdemeanor, the range of punishment is a fine only. You cannot be given any jail time. You only can be given a fine up to $500. Now, the Class C misdemeanors are cases that are handled in the city court or the JP court. For example, not having your seatbelt on is a Class C, speeding is a Class C, having a inspection sticker out of date, that's a Class C misdemeanor. And so the only way those cases come to this court is if a person is convicted in one of those courts, the JP court or the city court, and then they appeal their case. When they appeal their case, they get a whole new trial and it comes here. The range of punishment does not change. It's still the same, which means that if you are convicted of a Class C misdemeanor, you only can receive a fine, and the fine cannot exceed $500. Now, the next highest misdemeanor is a Class B misdemeanor. The range of punishment for a Class B misdemeanor is minimum 0 days to a maximum of 180 days, which is 6 months in the county jail, and a fine that does not exceed $2,000. Or you could be given both such fine and confinement. If a person is convicted of the Class A misdemeanor, which is the highest misdemeanor, the range of punishment is minimum 0 days to a maximum of 365 days, which is a year in the county jail, or a fine from $0 to $4,000. It cannot exceed $4,000. Or you could be given both such fine and confinement. Now, as a defendant in a criminal case, you have rights. One of the rights that you have is on the clipboard that has been handed out. And on that clipboard, it talks about your right to have an attorney. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. I'm going to go over that document with you. And it states that as a defendant in a criminal case, you have three options regarding your right to have an attorney. Number one, you may hire an attorney. Number two, if you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you. Or number three, if you want to represent yourself, you can, but you have to first waive or give up your right to have an attorney to represent you. Now, if you want your case, if you want to hire your own attorney and you have enough money to hire an attorney, your case will be reset. Reset means that you'll be given another court date to give you time to hire an attorney. If you want an attorney, but you do not have the money to hire an attorney, you will have to fill out a financial questionnaire. The financial questionnaire should be the third document on the clipboard that is titled Jefferson County Affidavit of Indigence. You have to fill out the first page of that document and half of the second page so that the proper person can determine whether or not you qualify for a court-appointed attorney. Now, if you want to represent yourself, that is, you want to waive your right to have an attorney and represent yourself, you will have to first sign a written waiver of your right to be represented by an attorney. The written waiver is titled Waiver of Counsel for purposes of entering a guilty plea or proceeding to trial. It should be the second document on the clipboard. You'd have to read and sign that document. I'm going to go over that document with you in about 1 or 2 minutes. Now, be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. Now, if you choose to give up your right to have an attorney and to represent yourself, you may change your mind at any time and request that an attorney be appointed to represent you. Now, at the bottom of that document, the first document that's titled Judge's Explanation of Rights to Defendants Without Attorney, it states in bold letters, defendant's choice, mark initials next to only one choice. If your choice is to hire your own attorney, then you will place your initials on the first line to the left. If you have already hired an attorney to represent you, then you will place your initials on the second line to the left and the name of the attorney on the line to the right. If your choice is to apply for a court-appointed attorney, then you will place your initials on the third line to the left. If you have already been appointed a court-appointed attorney to represent you in this case, then you will place your initials on the fourth line to the left and the name of the attorney on the line to the right. If your choice is to waive your right to have an attorney to represent you, that means you would like to give up your right to have an attorney to represent you and you desire to represent yourself, then you will place your initials on the fifth line to the left. Now, once you have finished initialing one of the 5 lines at the bottom of that document, then you will sign your name on the line that is titled defendant, and you will date it today's date, April 9th of 2024. Now, for those of you who will be waiving your right to an attorney and representing yourself, then you would have to read and sign the next document that is titled Waiver of Counsel for purposes of entering a guilty plea or proceeding to trial. And I'm going to go over this document with you, and it reads as follows. I have been advised of the nature and charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily. Voluntarily means that you're doing it of your own free will. And intelligently, intelligent means that you know what you're doing. So it says, my waiver is voluntarily and intelligently made. Furthermore, I have been advised this 9th day of April of 2024 by the County Court at Law, number 2, of my right to representation by counsel in the case pending against me. I have been further advised that if I am unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed for me free of charge if I am not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel. If that is your choice, then you will sign your name on the line that is titled defendant, and you will date it today's date on the line that is titled date. And again, today's date is April 9th of 2024. Now, as a defendant in a criminal case, you also have a right to have a trial by jury, where the young man is sitting in that area over there. We call that the jury box. That's where the jurors sit. 6 citizens from Jefferson County will be selected to serve as jurors in your case. They will listen to all the evidence. They will listen to all the arguments. They will deliberate, and then they will decide to find you either not guilty or guilty of your charge. You also have a right to waive your right to have a jury trial. Waiving your right to have a jury trial means that you have a right to give up your right to have a jury trial. If you do so, then your case will come before the court or the judge in one of 3 ways. One way it will come before the judge is by way of a trial without a jury. We call that a bench trial. Then the judge will listen to all the evidence. The judge will listen to the arguments, and then the judge will decide whether or not to find you guilty or not guilty based on the law and the facts of the case. Another is by way of a plea bargain. It can come before the court by way of, and now what a plea bargain is, it's an agreement that you work out with the district attorney's office to settle your case. We call that a plea bargain. If you're able to work out a plea bargain, then we will call that an agreed plea bargain. So the second way your case can come before the court is by way of an agreed plea bargain. You and the state have reached an agreement to settle your case. So let's say, for example, you and the state has reached an agreement, and the state say, well, judge, The agreement is we're going to give this person probation. Now and then it comes before the court, and the court says, well, the court has two options. The court can accept or reject the plea bargain agreement. When I say the court, I'm talking about the judge. The judge can either accept or reject the plea bargain agreement. If the judge rejects the plea bargain agreement, then you have a right to withdraw your plea, which means you have a right to take back your plea. So, for example, the state and you have reached an agreement, and the agreement is for probation. It comes before the court, and the court says, well, I'm not following that plea bargain agreement. Well, you say, well, judge, I take my plea back. I'm not pleading guilty, or I'm not pleading no contest to this charge. You have a right to do that. All right. Now, before I go any further, I use the terms pleading no contest and pleading guilty. Okay. You can enter one of three types of pleas. You can enter a plea of not guilty. If you do so, he's telling the court that you did not commit the offense that you've been charged with. Or you can enter a plea of guilty. If you do so, you're telling the court that you committed the offense that you've been charged with. Or you can enter a plea of what we call no contest. No contest means you're not fighting the charges, or you're not contesting the charges. So those are the three types of pleas that you can enter. Now, I said earlier that your case will come before the judge in one of three ways if you waive your right to have a jury trial. One way is by way of a bench trial. The other way is by way of an agreed plea bargain agreement. Now, with the agreed plea bargain agreement, I stated that if the court rejects the plea bargain agreement, you have a right to withdraw or take back your plea. Now, if the court follows or accepts the plea bargain agreement, and if you decide within 30 days that you would like to appeal your case because, one, you think you've been wrongfully convicted or the court committed an error by convicting you, then you have to get permission from the judge or from the court that went along with the plea bargain agreement. If the court gives you permission to appeal your case will leave this court and go to another court for them to review to see whether or not you were wrongfully convicted or whether or not the court committed an error by convicting you. The court that it will go to is called the Ninth Court of Appeals. The Ninth Court of Appeals is right above us on the third floor. They will review the case. They will decide whether to grant or deny your appeal. If they grant your appeal, they can just simply find you not guilty, or they can send the case back down to this court and order this court to give you a whole new trial. Or they can, if they reject or deny your appeal, then you can appeal it to a higher court than the Ninth Court of Appeals. You can file what is called a pro se petition for discretionary review, and I'll explain that to you. Pro se means that you're doing it on your own. You don't have a lawyer. And if you're petitioning the Texas Court of Criminal Appeals, which is the highest criminal court in the state of Texas, to review your case. And they can do one of two things. They could either grant or deny your petition. If they grant your petition, they can simply find you not guilty, or they can send the case back up to the Ninth Court of Appeals, or they can send it back down to this court and order this court to give you a whole new trial. If they deny your pro se petition for discretionary review, then at that point, your conviction will stand. Okay. Now, the other way that your case will come before the court, one way I say it could come by way of a bench trial, or it could come by way of an agreed plea bargain. The third way that it can come before this court is by way of an unagreed plea bargain agreement. And what that simply means is you and the state have not been able to reach an agreement to settle your case, and therefore you want the judge to assess the punishment. We call that an unagreed. For example, let's say the state is offering you 30 days in jail. And you say, well, I'm not taking 30 days in jail. I want the judge to set my punishment. So it comes before the judge. That's called an unagreed plea bargain agreement. Now, once it comes before the judge, then the judge can assess the punishment anywhere within the punishment range. For example, if it's a class A misdemeanor, anywhere from 0 days to 365 days, or a fine up to $4,000, or you could be able to give them both such fine and confinement. If it's a class B, 0 days to 180 days, or a fine that does not exceed $2,000, or you could be given both such fine and confinement. And you may qualify for probation. There are two types of probation. One type of probation is called adjudicated probation, and the other type is called unadjudicated probation. Now, I explain that to you I explain to you right now. Adjudicated probation, we call it regular probation. With adjudicated probation, you will have a conviction on your record as soon as you get on probation. However, there is something that is called judicial clemency. What that means is the court or the judge can set aside your conviction. In essence, it could take your conviction away. In order for that to happen, one of three things, in order for that to happen, you have to first successfully complete the probation. You cannot have any more time left on the probation. And you have to be successfully discharged, let off of the probation by the probation department. If those three things happen, then the court has the discretion to set aside the conviction. That simply means that you will no longer have a conviction. However, if you get a subsequent conviction, if you get a conviction later on, then this case that you got judicial clemency on can be resurrected, revived, brought back up, and used against you. And if you try to get a license with CPS, they can either deny giving you a license, or if you have a license, they can revoke or suspend the license that you have. Now, the other type of probation is called unadjudicated probation. You have adjudicated and unadjudicated. With unadjudicated probation, if you get on that unadjudicated probation, you will not have a conviction on your record when you get on the probation. If you successfully complete the probation, the case will be dismissed. And you may qualify for a non-disclosure. What a non-disclosure is, it basically means that the general public cannot have access to your record. Your record will be sealed to the general public. Now, I use the term general public. The government can have access to police department, schools, any government agency, they can have access. But most of the public is the general public. They cannot have access to it. Like if you have an employment somewhere and they're not a government employee, they can't have access to that record because it's been sealed to them. Okay? Now, as a defendant in a criminal case, you also have a right to have witnesses to come to court. That chair over there where the microphone is in front of it, we call that the witness stand. And what witnesses do, they can come into court, they can testify for you, or they can testify against you. If you represent yourself, you can ask them questions. If you have a lawyer representing you, your lawyer can ask them questions. We call that either direct examination or cross-examination. You also have a right to waive or give up your right to have witnesses to come to court. And what that means is, if you waive or give up your right to have witnesses to come to court, it means that you will not be calling witnesses. It does not mean that the state will not be calling witnesses, because the state will be calling witnesses. And you also have what we call a Fifth Amendment right against self-incrimination. And what that means is, I know if you watch television or if you see people say, well, I take the fifth. I mean, I'm not saying that. That, in essence, they're exercising their Fifth Amendment right against self-incrimination. they don't have to testify in their case. They don't have to say anything. The state, the government, the district attorney's office cannot force you to take the witness stand to testify against yourself if you exercise your Fifth Amendment right against self-incrimination. Now, you can waive or give up your right against self-incrimination. And by doing so, if you say, well, I want to take the stand, I'm giving up my Fifth Amendment right against self-incrimination, then you will be taking the witness stand. Okay? Now, you also have a right to have what we call discovery. Discovery means you have a right to see the evidence that the state has against you. You know, they have a file, you have a right to see your statement, witness statements, police reports, lab reports. You have a right to see video recordings, listen to audio recordings. You have a right to see the instruments that they may have or be using against you in your case. We call that discovery. In essence, you have a right to discover or see, have access to the evidence that they have and that they will be using against you. You also have a right to waive your right to have discovery. That is, give up your right to have a discovery. And if you waive or give up your right to have discovery, that means that you will not be having access to the evidence that the state has against you. So for every right that you have a right to exercise it or you have a right to waive it or give it up. All right. Now, Jefferson County has, well, everyone that's here for arraignment, you're here because you were arrested and you were bonded out of jail, and you bonded out either in one of three ways. You either paid a cash bond. A cash bond means that you paid the full amount of the bond to get out of jail, or you paid a surety bond. Surety bond means that you paid a bondsman a percentage of the bond to get out of jail, or you were released on a PRA bond or a personal recognizance bond, which means that you did not have to pay any money to get out of jail. You were released under your own personal recognizance with a promise to appear here in court. Every day that you spent in jail, you can get credit towards your sentence. For example, let's say you were in jail 1 minute and you bonded out. Okay, you went in there 1 minute, boom, you bonded out. That's considered 1 day. Okay, so let's say you went in jail, you booked in at 11:59 p.m., right? And you booked out 2 minutes later at 12:01 a.m. That's 2 days. They call it 2 different days. You don't go by 24 hours. Okay. So every day that you spent in jail, it can be used as credit toward your punishment. So for example, let's say you spent 5 days in jail and you and the state have worked out an agreement for you to serve 5 days in jail. What that means is you will not have to serve any more time in jail because you've already served 5 days in jail. Therefore, you'll be given credit for the time that you have already served. Now, if the state is offering you 7 days in jail and you spent 5 days in jail, that means we're going to subtract the 5 from the 7, that leaves 2. That in essence, you'll have to serve 2 days in jail instead of 7 because you have credit for the 5. Now, every day that you spent in jail can also be used as credit toward your fine and court costs. So for example, every day that you spent in jail, you receive $100 of credit that will go towards your fine and court costs. So if you spent 5 days in jail, 5 times 100 is $500. Okay, so that's $500 that can go toward your fine and court costs. So if the state is offering you fine and court costs of $500, that means you don't have to pay nothing. Why? Because you serve 5 days in jail, that's $500, and you'll be given credit for that $500 that will go towards your fine and court costs. And so the court costs will be taxed and retired, which means you don't have to pay anything. Now, if the state is offering you fine and court costs of $700 and you spend 5 days in jail, which is $500, we're going to subtract the 500 from the 700, that leaves 200. So you would have to pay $200 fine and court costs instead of 700 because you have credit for the 500. So if you cannot pay the $200 fine and court costs, then the court can put you on what is called a payment plan, which means you could pay off so much a month until the $200 is paid off. But let's say because of your financial situation, you still will not be able to pay the $200. No problem, because the court can convert the $200 to community service. And with the community service, every 1 hour of community service that you perform at a nonprofit organization, you will receive $12.50 that will go toward your fine and court costs. So for example, if you work an 8-hour day, that's $100. So if you owe $200, you work 2 8-hour days, that's $200, and that will satisfy your fine and court costs. Now, if you have not been in trouble before, this is your first time getting into trouble, well, the district attorney's office has a program that is called pretrial diversion. It's for first-time offenders only. And what they will do, they will dismiss your case. In order to qualify for the program, again, this has to be your first time getting in trouble. 2, it cannot be an offense involving unlawful carrying a weapon or resisting arrest. And 3, you have to have an attorney to help you to fill out the application to the district attorney's office. Now, if you get into the program, as I mentioned earlier, they will dismiss your case, and once you complete the program, you can get it expunged from your record. Expunged means erased, deleted, or wiped off from your criminal record. It's just like, you look at this page, you know, you got writing here, this is your criminal record. When they get expunged, it looks like this, nothing. Okay, and so if you're interested in the program, just let us know, and we can direct you to your proper source. Or if you get an attorney, you can tell the attorney, you can ask the attorney to apply for the program to get you into the program. All right. Now, if you are a veteran of any one of the branches of the United States military, Jefferson County has a program which is also part of the pretrial diversion program. The program is called Veterans Court. It's for veterans only. And the only qualification, you just have to be a veteran of any one of the branches of the United States military. And if you qualify and get in the program, they will, once you complete the program, they will dismiss your case, and you can get a non-disclosure. And that simply means that they will not disclose your record to the general public. It will be sealed. Okay? And if you're interested in that program, just let us know. We have paperwork that we can get to you so that you can apply for that program. Now, this court, Jefferson County Court at Law Number 2, has a program that I started within the first 100 days of taking office in March of 2017. The program is called the CSI program. CSI stands for Community Safety Initiative. It is a program that is designed to address the issue of what we call recidivism. Recidivism is when people commit crimes over and over. And the way we address the issue of recidivism is through our Community Safety Initiative. With the Community Safety Initiative, we have partnerships with local agencies. One of the local agencies that we have a partnership with is the Spindletop Center. Spindletop is our local mental health center. We have folks here from Spindletop. They're going to come to you in a little bit and tell you more about the program. But basically, the program entails that Spindletop will perform a private interview. They can develop an assessment, and then they can develop a treatment plan for either outpatient or inpatient treatment, depending on your mental health needs. Now, in order to be in the program, you do not have to be insane or incompetent. You can just simply suffer from depression or anxiety or any other host of mental illnesses. They have the expertise and the capability to address your mental health needs. If you have issues with drugs or alcohol, you may be dependent on drugs or alcohol. Well, Spindletop has a program that is called ATAR. ATAR is an acronym that stands for Addiction Treatment and Recovery. Or we also have a program, we have a partnership with our local Drug and Alcohol Council. They have a program for drug and alcohol recovery that is called OSAR, OSAR. OSAR stands for Outreach, Screening, Assessment, and Referral. Both of those programs are drug and alcohol treatment programs. With those programs, they will perform a screening, an assessment, and they can refer you for either outpatient or inpatient treatment, depending on your drug or alcohol dependency needs. If you are unemployed or if you're looking for a better job, well, we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. Lamar University has a program that is called CICE. It's an acronym that stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry, the shipping industry, and the chemical industry. Once you are trained in any one of those areas that you select, then they will assist you at getting a job in the area that you select. If you have not graduated from high school and you would like to get your GED, your graduate equivalency diploma, well, CICE has a GED program. Now, all of these programs that I just mentioned to you will not cost you anything. They're free. Only thing it will cost you is time. And I like to say in this court, we do not just give time, we take our time. That is, we do not just arrest the problem, we address the problem. And we believe that if we address the problem, we can produce productive people. And if we produce productive people will not commit crimes. Why? Because they have too much to lose. And so I also say that when you come to County Court at Law number 2, we do not just have court as usual, we have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that comes before the court. And if we make a difference in their life, then we will make a difference in their home. And if we make a difference in their home, we will make a difference in the community, because what comes out of the home goes into the community. So if you're interested in any one of these programs, just please let us know. And we have brochures that we can give to you so that you can get into any one of these programs. And as I mentioned earlier, we have some folks here from Spindletop who's going to come forward and tell you a little bit more about the program and programs that Spindletop has to offer. At this time, I'm going to have Deputy Hinton and Chris come forward.
Thank you, Your Honor.
You're welcome.
Good morning. Judge Sand, my name is Steve Hinton. I'm a mental health deputy licensed by the state commission here at the sheriff's office. My coworker here, Chris. Now, Chris is a qualified mental health professional. The reason we are both here this morning in this courtroom is the judge cares about every single person that comes to the bench. What the judge has found, what statistics prove, is those who have legal issues commonly have mental health needs, substance use disorders, or sometimes just lack of community resources.
So, as I talked about, this is not how these things Question things that we all know that some point in time, they're not necessarily making you, but being in the court process. There's a lot of really great community resources. I know the judge mentioned inpatient and outpatient, we can get your information. We're not ever gonna send you guys anywhere. It's just getting you whatever information you may need for yourself or for someone you care about. That's the big thing about this, is that we're a giant loophole, because we know that there's a lot of really great resources that are well funded, but they're not well advertised, and sometimes just finding them is a bit like jumping through hoops. It doesn't matter if the resource you need is just support, that's also what we're here for. It's just one of those things where if you let us know what you need, we can work with you, we can find something.
Now, maybe this is your first time to be in court, maybe it's your 10th time to be in court, there's still hope. In fact, what we're offering you today has the ability to change your life, but we're gonna need something from you. We need you to share that need with us, and Chris will explain exactly how you can do it, where you can find it.
Usually we're handing this out as you guys walk in, we got people tied up on with the other court. We're all handing this out in just a second to every single person, because as I said, it doesn't matter if the information is for you or someone you care about. It doesn't matter if you're here as a defendant, it doesn't matter if you're here to support, it doesn't matter what you are trying to find out. We exist as a loophole. We are only here to help, and it doesn't matter what way we can help, we just want to have a chance to do that. So this is definitely a baseline of a consent. The only thing you are consenting to on this is me contacting you once in a minute you're choosing, or if you're in Orange County, Michael contact me once in a minute you're choosing. Now, that can be text, that can be called, that can be speaking privately today. If you want to speak privately today, we can do that during the recess, or if you want to schedule a talk. Because again, we do understand that support is a lot of times a resource that we need, and you don't really find it outside of here. It shouldn't be the place where we are offering community support, it should be outside the courtroom too. But we want to use one of those. We understand that you guys all shut up. I'm sure there's plenty of names that were called outside that did not come in here. You guys all took the time to be here. We know you work hard for yourselves. We just want to match it.
So also I have this flyer I want to give everyone before you leave here today. On the back, it tells you some of the advantages of actually participating, but on the front, it also has a 1-800 number. If you do find yourself in an unsafe place, you can call that number and get help immediately.
So the big thing about that 1-800 number, as I said, work with anyone, right? It also doesn't matter if you're from Jefferson County, because as we know, like people from the court in Jefferson County, there's nowhere close to here, right? That flyer, the number on it is actually pretty much statewide. I say pretty much because we all understand that Texas has some places where no phone numbers work. That number is 24/7. You can call it at 6 a.m. on Christmas Day and you need to talk to somebody. It is a crisis number. There's another hotline number on there too. But if you need something outside of that, if it's not a crisis, but you just want to talk, please let us know. If there's something you're trying to find or get set up, it's really the only thing we are here for, is to help in whatever way we can.
And just shortly, the court is going to go into recess, and when it does, we'll be able to come out there. We'll give you those documents for you to fill out, and we'll also hand this out to you at that time. We'll be able to answer any questions you have as well. Thank you, Your Honor.
Thank you, Deputy Henry and Chris. Okay, ladies and gentlemen, we're going to be going into recess in a few minutes. But before we go into recess, I need to give you some instructions. Now, the paperwork that you have on the clipboard, we're going to pick that paperwork up from you. So make sure that you have it filled out properly. If you need assistance in filling out the paperwork, we have our court personnel who's here who will be happy to assist you at filling out the paperwork. Now, it's going to take us a few minutes to pick up the paperwork and then evaluate the paperwork. And so while that is going on, if you need to use the restroom, there are 2 restrooms right outside in the hall. The men's restroom is in front of County Court at Law number 3. And the women's restroom is on the opposite side of the hall in front of the 172nd District Court. Now, please do not leave the courthouse. If you leave the courthouse and if we call your name for your case and you're not here, your bond can be forfeited. And if your bond is forfeited, a warrant will be issued for your arrest, and you'll be arrested and placed in the Jefferson County Jail. Now, this is going to take us a few minutes to get through. Once we finish here, then you'll be able to leave. Now, we're going to call you up one at a time once we finish with the paperwork. So at this time, the folks from Spindletop, they're going to come out and visit with you some more. And again, if you need to use the restrooms, just there are two in the hallway. And if you need assistance with filling out the paperwork, just simply raise your hand and then we'll get the assistance to you. Okay? So at this time, the court will be in recess. Jefferson County Court at Law number 2 is back in session. The court is in session in 2 cases. They are cause number 23CCCR 0622, cause number 23CCCR 1775. Both cases are style of state of Texas versus Nicodia Bill Davis Jr. Mr. Davis, would you please come forward? Mr. Davis, your full name is Nicodia Bill Davis Jr.?
Yes, sir.
Davis, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God?
Yes, sir.
You may put your hand down. How are you doing, Mr. Davis? You doing okay? That's good. Mr. Davis, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
Is this your signature on the line that side of defendant?
Yes, sir.
And are these your initials on the line that state that you like to have your case reset to hire your own attorney?
Yes, sir.
Mr. Davis, before you signed and initialed this document, did you read the document?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in this document true and correct to the best of your knowledge?
Yes, sir.
Okay. Mr. Davis, your case is going to be reset to give you an opportunity to hire your own attorney. But before your case is reset, I need to give you some bond conditions. Ms. Bailiff, would you please hand these bond conditions to Mr. Davis? Mr. Davis, the bailiff has just handed you some bond conditions. I'm going to go over these bond conditions with you.
Mhm.
The title is Standard Bond Conditions in County Court at Law number 2. Do you see that title?
Yes, sir.
Okay. And it reads as follows: following the return of a criminal information in County Court at Law number 2 of Jefferson County, Texas. All bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, the defendant shall commit no offense against this state, any other state, or of the United States. Do you understand that condition?
Yes, sir.
The defendant shall submit, that's number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. You understand that condition?
Mhm.
And let's see. Condition number 3, the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, other location frequented by the alleged victim. Do you understand that condition?
Yes, sir.
Condition number 4 does not apply because that only applies in a DWI case. Your case is not a DWI case. However, condition number 5 does apply. And it states the defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer as defined by section 1.07 Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition?
Yes, sir.
Now, Mr. Davis, if you violate any one of these conditions, your bond will be revoked. And if your bond is revoked, a warrant will be issued for your arrest. You'll be placed in the Jefferson County Jail. Do you understand?
Yes, sir.
Now, Mr. Davis, you can have stand in front of our court coordinator. She's going to reset your case. Once you get your reset, you'll be free to go and you have a blessed day. Next case is cause number 24CCCR 0018. Case is style of state of Texas versus Valerie Meehan. Ms. Meehan, your full name is Valerie Meehan. Ms. Meehan, would you please raise your right hand? Ms. Meehan, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? You may put your hand down. How are you doing, Ms. Meehan? You okay? That's good, Ms. Meehan. I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes,
Is this your signature on the line that's titled Defendant?
Yes.
And all these your initials on the line that state you'd like to apply for a court-appointed attorney?
yes.
I also have a document that is titled Jefferson County Affidavit of Indigence. Ms. Meehan, do you recognize this document?
Yes.
And on page 2 of this same document, there's a signature above the line that is titled Defendant. Signature, is this your signature?
Yes.
Ms. Meehan, before you signed and initialed these documents, did you read the documents?
Yes.
Did you understand what you read?
Yes.
And is everything in these documents true and correct to the best of your knowledge?
Yes.
Ms. Meehan, I read your answers based on the answers to meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Giles Cole. Attorney Cole will be given information to contact you, and you will also be given information to contact him. Our court coordinator will give you that information, but before she gives you that information, I need to give you some bond conditions. Ms. Meehan, you just been handed a document that is titled Standard Bond Conditions in County Court at Law Number 2. Do you see that title?
Yeah.
Okay, I'm going to go over these bond conditions, which and it reads as follows. Following return of an information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or the United States. Do you understand that condition?
Yeah.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yeah.
And condition number 3, the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition?
Yes.
Now, condition number 4 does not apply because that only applies in a DWI case. Your case is not a DWI case. However, condition number 5 does apply. And condition number 5 states as follows. The defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer as defined by section 1.07 Penal Code, actively engaged in employment as a sworn, full-time paid employee of a state agency or political subdivision. Do you understand that condition?
Yes.
Ms. Meehan, if you violate any one of these conditions, your bond will be revoked. And if your bond is revoked, the warrant will issue for your arrest and you'll be placed in the Jefferson County Jail. Do you understand that?
Yes.
Okay. Now, have a seat in that first chair by the wall. And when the court coordinator is ready for you, she'll call you up to a window. Once you finish at the window, you'll be free to go and you have a blessed day. Linda Wyckoff. This is cause number 24CCCR 0246, case of style state of Texas versus Linda Wyckoff. Ms. Wyckoff, is that your full name?
Yes, sir.
Ms. Wyckoff, would you please raise your right hand? Ms. Wyckoff, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Ms. Wyckoff, you may put your hand down. How are you doing, Ms. Wyckoff?
Good.
That's good, Ms. Wyckoff. I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant? Are these your initials on the line that state you would like to apply for court-appointed attorney? I also have another document. This document is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes.
On page 2 of this same document, there's a signature above the line that is titled Defendant Signature. Is this your signature?
Yes, sir.
Ms. Wyckoff, before you signed and initialed these documents that I just showed you, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes,
And is everything in these documents true and correct to the best of your knowledge?
yes, sir.
Ms. Wyckoff, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. The attorney that will be appointed to represent you in this case is Attorney Peter Dole. Attorney Dole will be given information to contact you. You will also be given information to contact him. Our court coordinator will give you that information. Once you get the information from the court coordinator, you'll be free to go and you have a blessed day. Please have a seat in that first chair by the wall. Thank you. Next case is cause number 24CCCR0264. Case is styled the state of Texas versus Jesus Eduardo Leon Campos. Mr. Campos, your full name is Jesus Eduardo Leon Campos. Mr. Campos, would you please raise your right hand? Mr. Campos, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Campos, you may put your hand down. How are you doing, Mr. Campos?
Great.
That's good. Mr. Campos, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without an Attorney. You recognize this document? And is this your signature on the line that's titled Defendant?
Yes.
Are these your initials on the line that state you'd like to apply for court-appointed attorney? I also have another document that's titled Jefferson County Affidavit of Indigence. You recognize this document?
I know.
On page 2 of the same document, there is a signature above the line that is titled Defendant's Signature. Is this your signature?
Yes.
Mr. Campos, before you sign and initial these documents, did you read the documents? Did you understand what you read? Is everything in these documents true and correct to the best of your knowledge? Mr. Campos, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. The attorney that will be appointed to represent you in this case is Attorney Mark Faggett. Attorney Faggett will be given information to contact you. You will also be given information to contact him. Our court coordinator will give you that information. Please have a seat in that third chair. Once you get that information from the court coordinator, you'll be free to go and you have a blessed day. Same to you. Next case is cause number 24CCCR0318. Case is styled the state of Texas versus Desmond Spencer. Mr. Spencer, your full name is Desmond S. Spencer.
Yes, sir.
Mr. Spencer, would you please raise your right hand? Mr. Spencer, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Spencer, you may put your hand down. How are you doing, Mr. Spencer?
Good.
That's good, Mr. Spencer. I have before me two documents. The first document is titled Judge's Explanation of Rights of Defendants Without Attorney. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line state you would like to apply for court-appointed attorney?
Yes, sir.
I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
On page 2 of the same document, there is a signature above the line that is titled Defendant's Signature. Is this your signature?
Yes, sir.
Mr. Spencer, before you sign and initial these documents that I just showed you, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Spencer, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. The attorney that will be appointed to represent you in this case is Attorney David Grove. Attorney Grove will give information to contact you. You will also be given information to contact him. Our court coordinator will give you that information. So once you get the information from the court coordinator, you'll be free to go. And you have a blessed day. Please have a seat in that first chair on the wall. Next case is cause number 23CCCR 1454. The case is style of state of Texas versus Charles Boyd. Mr. Boyd, would you please come forward? Mr. Boyd, your full name is Charles Boyd.
Yes, sir.
Boyd, would you please raise your right hand? Mr. Boyd, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Boyd, you may put your hand down. How are you doing, Mr. Boyd? Doing all right? That's good. Now, Mr. Boyd, I have before me a document that is titled Judge's Explanation of Rights of Defendants Without Attorney. You recognize this document? And is this your signature on the line that's titled defendant?
Yes, sir.
Or these your initials on the line that state you'd like to apply for court-appointed attorney?
Yes, sir.
I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
On page 2 of the same document, there's a signature above the line that is titled Defendant's Signature. Is this your signature?
Yes,
Mr. Boyd, before you sign and initial these documents, did you read the documents?
yes.
Did you understand what you read? Is everything in these documents true and correct to the best of your knowledge?
Yes.
Mr. Boyd, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of court-appointed attorney. The attorney that will be appointed to represent you in this case is Attorney Jack Lawrence. Attorney Lawrence will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go. And you have a blessed day. Please have a seat in that 5th chair on the wall. There you go.
Okay, I'm trying to get it.
I'll put them in order.
Okay.
Next case is cause number 23CCCR 1404. Case is style of state of Texas versus Tyron James Houston. Mr. Houston, your full name is Tyron James Houston. Mr. Houston, would you please raise your right hand? Mr. Houston, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Houston, you may put your hand down. How are you doing, Mr. Houston? You doing good? Okay, now, Mr. Houston. I have 2 documents before me. The first document is titled Jefferson County Affidavit of Indigence. You recognize this document? Is this your signature on the line as titled defendant? Are these your initials on the line that state you'd like to apply for court-appointed attorney? I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document? On page 2 of the same document, there's a signature above the line that is titled Defendant Signature. Is this your signature? Now, Mr. Houston, before you sign and initial these documents, did you read the documents? Did you understand what you read? Is everything in these documents true and correct to the best of your knowledge? Okay, Mr. Houston, I read your answers. Based on your answers, you do not meet the eligibility requirements for the appointment of a court-appointed attorney. So at this point, you could do one of 2 things. You can have your case reset to hire your own attorney, or you can waive your right to an attorney and represent yourself. And what I'll do, Ms. Bailey. You put this on a clipboard, give it back to him. He can have a seat in that chair at the table. Yeah, it has a clipboard right here. You're gonna give you that clipboard, and so you can make your change on that document. on the first document, okay? Just have a seat at that table. Next case is cause number 23CCCR 1222, case of Style State of Texas versus Gabriel Isaac Mace.
Jesus.
Mr. Mace, your full name is Gabriel Isaac Mace. Mr. Mace, would you please raise your right hand? Mr. Mace, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Mace, you may put your hand down. How are you doing, Mr. Mace? I'm doing fine, thanks, Sergeant. Mr. Mace, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? And is this your signature on the line as titled defendant? And are these your initials on the line that state you'd like to apply for court-appointed attorney? I also have another document that is titled Jefferson County Affidavit of Interest. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there are a set of there's a signature above the line that is titled Defendant's Signature. Is this your signature?
Yes, it is.
Mr. Mace, before you signed and initialed these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct
Yes, sir.
to the best of your knowledge? Mr. Mace, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you is Attorney Todd LeBlanc. Attorney LeBlanc will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go. And you have a blessed day. Please have a seat in that third chair on the wall, right there.
Thank you.
Terrence Houston. Okay, now, Mr. Houston, you was previously sworn in, is that correct? And you've changed your mind. You said you want to have your case reset to hire your own attorney? Okay. So, Mr. Houston, your case is going to be reset to give you an opportunity to hire your own attorney. I guess you could just have a seat back at that table where you're sitting. Next two cases are cause number 23CCCR 1432 and cause number 23CCCR 1519. Both cases are titled The State of Texas versus Aaron Jerome Tompkins. Mrs. Tompkins, could you please come forward? Mr. Thompson, your full name is Aaron Jerome Tompkins.
Yes, sir.
Tompkins, would you please raise your right hand? Mr. Thompson, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Tompkins, you may put your hand down. How are you doing, Mr. Tompkins? You doing good? That's good. Now, Mr. Tompkins, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? And is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that state you'd like to apply for court-appointed attorney?
Yes, sir.
Also have another document that is titled Jefferson County affidavit of indigence. And do you recognize this document? On page 2 of the same document, there is a signature above the line that is titled defendant signature. Is this your signature?
Yes, sir.
Mr. Tompkins, before you signed and initialed these documents, did you read the documents?
Yes, sir.
Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Okay, Mr. Tompkins, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. Our court coordinator will give you information on how to contact the court-appointed attorney, and the court-appointed attorney will give information on how to contact you. And the court-appointed attorney in this case is Mr. John Macy. Okay? Now, before our court coordinator give you that information, I need to give you some bond conditions. The bailiff is going to hand you some bond conditions. I'm going to go over these bond conditions with you. And the bond conditions, there's title standard bond conditions in County Court Law number 2. Do you see that title?
Yes, sir.
Okay, I'm going to go over this document with you, and it reads as follows. Following return of a criminal information in County Court Law number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yeah.
Condition number 2, the defendant shall submit to testing for drugs and alcohol anytime as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs, alcohol in the defendant's body. Do you understand that condition?
Yeah.
And condition number 3, the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go to any residence, school, or other location frequented by the alleged victim. Mr. Tompkins, do you understand that condition?
Yes, sir.
Now, condition number 5 does not apply. Condition number 4 does not apply. Condition number 5 does apply. And condition number 5 states the defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer as defined by section 1.07 Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition?
Yes, sir.
Now, Mr. Tompkins, if you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, a warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Do you understand that?
Yes, sir.
Okay. Just have a seat in that first chair. Wait for your name to be called. Once your name is called, you'll be free to go once you finish that one. Miss Bozeman, would you get Miss Jennifer? Next case is cause number 23CCCR1382, case style state of Texas. Well, cause number 23CCCR1356, the case style state of Texas versus Nathaniel Willie. Mr. Willie, your full name is Nathaniel Michael Willie. Mr. Willie, would you please raise your right hand? Mr. Willie, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Willie, you may put your hand down. How are you doing, Mr. Willie?
Pretty good. How about yourself?
I'm doing fine. Thanks for asking. Mr. Willie, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendants?
Yes, sir.
And are these your initials on the line that state you'd like to apply for a court-appointed attorney? I also have another document that is titled Jefferson County Affidavit of Indigence. You recognize this document?
Yes, sir.
On page 2 of this document, there's a signature above the line that's titled Defendant Signature. Is this your signature?
Yes, sir.
Mr. Willie, before you signed and initialed all of these documents that I just showed you, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes.
And is everything in these documents true and correct to the best of your knowledge?
Yes.
Mr. Willie, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Ms. Reagan Minaldi. Ms. Minaldi will be given information to contact you, and you will also be given information to contact her. Once our court coordinator give you that information, you'll be free to go, and you have a blessed day. Now, let's see, that's really. I have the bond conditions. Oh, well, here we go. Now, Mr. Willie, I have some bond conditions that the court bailiff is going to hand to you, and I'm going to go over these bond conditions with you. Mr. Willie, the title of that document is Standard Bond Conditions in County Court at Law Number 2. Do you see that title?
Yes, sir.
And it reads as follows: following the return of a criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or of the United States. You understand that condition?
Yes, sir.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and a test indicates the presence of drugs, alcohol in the defendant's body. You understand that condition?
Yes, sir.
And condition number 3, the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. You understand that condition?
Yes, sir.
And condition number 4 does not apply. However, condition number 5 does apply. Condition number 5 states that the defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer as defined by section 1.07 Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition?
Yes, sir.
Now, Mr. Willie, if you violate any one of these conditions, your bond will be revoked, and if your bond is revoked, a warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Do you understand that?
Yes, sir.
Okay, Mr. Willie, please have a seat in that 5th chair on the wall. Wait for your name to be called. Next case. Fernando Lopez. Okay, this is cause number 23CC 1382. Case is titled State of Texas versus Fernando Lopez. Mr. Lopez speaks Spanish.
Is it chargeable?
He may speak some English. However, we have our court interpreter or translator, Ms. Jennifer Raji. Ms. Raji, would you please raise your right hand? Ms. Raji, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
Ms. Raji, you may put your hand down. How are you doing, Ms. Raji?
Good, Judge Holmes.
I'm doing fine, thanks for asking. Ms. Raji asks Mr. Lopez if his full name is Fernando Lopez.
Yes.
Okay. Ask Mr. Lopez to please raise his right hand. Mr. Lopez, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Okay,
Yes.
you may put your hand down. Ask Mr. Lopez how he's doing. Yeah, good. Mr. Lopez, I have before me 2 documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes.
Is this your signature on the line inside the defendant?
Yes.
Excuse me. Are these your initials? Okay, Are these your initials on the line that's titled or that states you'd like to apply for court-appointed attorney?
Yes.
Is this your signature? Well, do you recognize this document?
Yes.
Is this your signature on the line that's titled defendant signature?
Yes.
Now, before you sign and initial these documents, did someone over these documents with you in Spanish?
Yes, his mother.
Did you understand everything that they went over?
Yes.
Is everything in these documents true and correct to the best of your knowledge?
Yes.
Okay, Mr. Lopez, I read your answers. Based on your answers, you meet your requirements for the appointment of a court-appointed attorney. The attorney that will be appointed to represent you is Attorney Charles Rojas. Attorney Rojas will be given information to contact you, and you will be given information to contact him. The court coordinator will give you that information. Once you get the information from the court coordinator, you'll be free to go and you have a blessed day. How you want to handle this? You want him now? or-
He said you too, George, thank you.
Thank you. Just have him stand right there. It's the last one. And this will conclude the calling. Well, see if we have any bond forfeitures. Well, Okay. Mr. Simpson, this is cause number 24 CCCR 0248. Case is styled the state of Texas versus Tom Simpson. Mr. Simpson, is that your full name?
Yes, sir.
How are you doing, Mr. Simpson?
Mhm.
Okay. Now, Mr. Simpson, would you please raise your right hand? Mr. Simpson, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay. Now, Mr. Simpson, the document that you have before you is titled Judge's Explanation of Rights of Defendant Without Attorney. Now, as a defendant in a criminal case, you have a right to have an attorney. On that document, it talks about your right to have an attorney. Now, I'm going to go over this document, which it says as a defendant in a criminal case, you have three options regarding your right to have an attorney. Number one, you may hire an attorney. You understand that option?
Yes, sir.
Number two, if you do not have enough money to hire an attorney, you may request an attorney be appointed to represent you. Do you understand that option?
Yes, sir.
And number three, you may represent yourself. That is, you can waive your right to have an attorney or give up your right to have an attorney and represent yourself. Do you understand that option?
Yes, sir.
Okay. Now, if you want an attorney to represent you and you have enough money to hire an attorney, the case will be reset to give you time to do so. If you want an attorney and do not have the money to hire an attorney, you would need to fill out a financial questionnaire. Now, the financial questionnaire is the third document on that clipboard. It is titled Jefferson County Affidavit of Indigence. I'll go over that document with you as well. Now, it states that you would have to fill out that document so that the proper person can determine whether or not to appoint an attorney to represent you. Now, if you want to waive your right to have an attorney, that is, give up your right to have an attorney and represent yourself, you'll have the opportunity to speak to the prosecutor, which is the assistant district attorney that's behind you. You cannot speak to the prosecutor about your case unless you sign a written waiver of your right to be represented by an attorney. Now, the written waiver is the second document on the clipboard that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. I'll go over that document with you as well if that is your choice. Now, be aware that there are dangers to self-representation. Waiving your right to an attorney, representing yourself, may result in the worst outcome for you and your case, including the loss of significant rights and opportunities relating to military service, possessing of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to waive your right to have an attorney and to represent yourself, you may change your mind at any time and request that an attorney be appointed to represent you. Do you understand that?
Mhm.
Okay. Now, at the bottom of that document in bold letters, it states defendant's choice. Mark initials next to only one choice. If your choice is to hire your own attorney, then you will place your initials on the first line to the left. If you have already been appointed a court-appointed attorney to represent you in this case, then you'll place your initials on the second line to the left and the name of the attorney on the line to the right. If your choice is to apply for a court-appointed attorney, then you'll place your initials on the third line to the left and the name of the attorney on the line to the right. If you have already been appointed a court-appointed attorney to represent you, then you'll place your initials on the fourth line to the left and the name of the attorney on the line to the right. If your choice is to waive your right to have an attorney or give up your right to have an attorney and to represent yourself, then you'll place your initials on the fifth line to the left. Now, once you have finished initialing one of the 5 lines, you will sign your name on the line that is titled Defendant, and you will date it today's date, April 9th of 2024. Mr. Simpson, do you understand?
Yes, sir. We got put up on lawyer already.
If you have a court-appointed an attorney on this case, then you will place your initials on the fourth line to the left and the name of the attorney on the line to the right. Now, I'm looking at the docket sheet, and the docket sheet does not state that you have an attorney
I don't have it on this.
appointed to represent you on this case.
Sign for one.
Hmm?
Sign for one.
Okay, so if you're gonna ask for a court-appointed attorney, you'll have to place your initials on the third line to the left at the bottom. And you will date it today's date, April 9th of 2024. You're gonna have to take a seat at that table. And you will fill out the document that is titled Jefferson County Affidavit of Indigence. Okay, Mr. Simpson, just go take a seat and
Take
fill
it
out.
too.
Yes.
Yeah, you're taking the clipboard with you and the pen. You can show him what document he needs to fill out. If you need any assistance, we'll be able to have someone to assist you with filling out the document. Court will be in recess. Jefferson County Court, Law number 2 is back in session. The court is in session with the arraignment docket. The court will go over the bond forfeitures. First case is cause number 23CCR 1380. Case of Style of State of Texas versus Athea Marie Jones. Ms. Jones was scheduled to be in court this morning at 9 a.m. On today's date of April 9th, 2024, at or about 9 a.m. The court's will call the name of Athea Marie Jones at the courthouse door. Athea Jones did not answer. Athea Jones has not appeared in court since the court has been in session. The time now is 11:51 a.m. on today's date. Ms. Bailiff, would you please call the name of Athea Marie Jones at the courthouse door?
Yeah, Jones. Yeah, no.
Athea Jones' name was just called at the courthouse door. Athea Jones did not answer. A reasonable time has passed to give Ms. Jones an opportunity to appear in court. She has not appeared in court. State, do you have a motion?
Signal for bond forfeiture.
That motion will be granted. Athea Jones' bond will be forfeited and the warrant shall be issued for arrest in cause number 23CCCR 1380. Next case is cause number 23CCCR 1608. Case is styled State of Texas versus Larry Donnell Roberson Jr. Larry Roberson Jr. was scheduled to be in court this morning at 9 a.m. At about 9 a.m., the court's be able to call the name of Larry Roberson at the courthouse door. Larry Roberson Jr. did not answer. The time now is 11:52 a.m. on today's date. Ms. Bailiff, would you please call the name of Larry Roberson Jr. at the courthouse door?
Larry Robertson Jr. Larry Robertson Jr.
Larry Roberson Jr.'s name was just called at the courthouse door by the court's bailiff. Larry Roberson Jr. did not answer. A reasonable time has passed to give Mr. Roberson an opportunity to appear in court. He has not appeared in court. State, do you have a motion?
Signal for bond forfeiture.
That motion will be granted. Larry Roberson Jr.'s bond will be forfeited and the warrant should be issued for his arrest in cause number 23CCCR 1608. And this will conclude the calling of the court's arraignment docket in County Court at Law number 2 of Jefferson County, Texas. On today's date of April 9th, 2024, Judge Terrence Holmes presiding. Prosecutors, your excuse.
Thank you, Judge.
Everyone, please have a blessed day.